Доброго дня, шановні пані та панове. Вітаємо всіх в прес-центрі українського.
Good afternoon, dear guests. Welcome to the Ukrainian Crisis Media Center. We had come together to discuss of the Maidan cases and commemoration of the Maidan anniversary. We have Інна Плєханова, Юрій, Аксенин, two investigators, and good afternoon, dear friends. Unfortunately, the law enforcement bodies had become the criminal units and tried to turn the state into the criminal band. That's why we have questions to law enforcement agencies and request them to express their opinion whether the exchange can take place only in case people will be cleaned after all charges, and the attitude of the prosecutor's office and NBI to this issue, and also question about the work that you carried out during the period when we did not communicate to one another. Олексій Донський, investigator of the NBI. So first of all, about the statement made by the Russian authorities about full cleaning. I've heard that statements from mass media. I would like to say that it has no relation to our work. The so-called procedural cleaning as a notion does not exist in Ukrainian procedural law, and as to those statements, I do not see any use to respond to that. In line with our procedural code, we have to investigate charges, to file them to court, and seek for the court decision about those cases, including potential punishment. So I would advise that society pay less attention to what the officials from Russian Federation think on that matter. Currently, together with the prosecutors from the from the National Investigation Bureau, we work on the cases. We want to finalize them. We want to put forward the charges and file them to court. This is about the events between November 2013 and massive killings of people in February 2014. On March 17, we have scheduled court hearings about shooting on Institutska Street in Kyiv in February 2014. Our tactical consideration is that it is not useful now to disclose our tactical approach to the court hearings because we believe that any information which we as investigators may disclose at this stage might be adversely used by the lawyers of the alleged perpetrators. So I only can invite you to court or follow the online broadcasting of the court hearings. As of today, observing mass media reviews, we may expect some procedural adverse measures that might be taken by the lawyers of the Berkut soldiers. In the court hearings, we are not going to disclose our plans. What we will do in court, we continue our intensive work preparing to the court hearings, and we would like to ask why only two people had come back, not all 5 of them, where Sadovnik is, etc. In more details, the course of investigation may be described by my colleagues from the National Investigation Bureau. As of now, we investigate events of January and February in 2014. Today, our colleagues from the National Investigation Bureau work very hard, and we do not have any problems in communication. We believe that we have reached some results, and we expect to move forward rather efficiently. Good afternoon. I would like to report on the work of the National Investigation Bureau. I'm Chornoblawski Alexander, an investigator of the we have 37 employees, 37 investigators who have been dealing with the investigation of Maidan cases for 4 years now. We have a special unit which investigates the Maidan cases. We are located in the Prosecutor General office on Borisoglebska Street on the 5th and 6th floor. We are located there together with procedural judges, and we have 47 criminal proceedings which amount to more than 6,000 volumes of papers. We have regrouped that charges into criminal cases, for example, about murders or killings on Maidan. This case about killings on Maidan comprises more than 500 volumes, that is files with papers, and also all the investigators have good conditions for their work. and they can do their job, their everyday job. Each week, all the procedural results, every week all the procedural results are reported to the procedural judge. During the last month, we have carried out a huge amount of work. For example, a murder of Vasil Sergienko, journalist Vasil Sergienko, and we have finalized it. Also, we finalized our investigation about one of the judges who illegally detained people in February 2014. And very soon this case will be filed, this criminal case will be fined to court. Also, we had finalized several other cases and announced suspicion to judges, to chairman judges of Dniprovsky court who illegally took decision about detentions of people. This illustrates that the work continues. My question, I've read an information that for the that we have criminal persecutions and criminal proceedings against the Maidan investigators. No, I know nothing about that. We do not have this information. There are around 20 criminal proceedings against investigators which were opened upon claims from Yanukovych and his lawyers, Zakharchenko, Bogatyr and his lawyers. You should keep in mind that our criminal and procedural law, provides that at the level when the complaint is filed or request about persecution is filed or investigation, this case is simply registered, but then the investigation might be opened or not. According to our, my question about Babikov, I would like to hear your comments. Our understanding is that Babikov, during the briefing, he lied to us openly. And keeping in mind that we have 20 cases against Maidan investigators, they have a chance to influence. As far as my colleague mentioned, that we do not have these cases. And as my colleague mentioned, now we transfer cases to the National Investigation Bureau. That's why I can say that there is no impact of the National Investigation Bureau on the investigators of Maidan cases. If there would be any changes in this respect, I will inform you. I am a widow of Igor Shvets. I'm Tamara Shvets. I'm interested to know, on February 18, there was a terrible day, but nobody mentions this. There is one SBU general, then we can observe that on Institutska Street the proofs are being destroyed. It is planned to remove the pavement. It is also planned to cut that hill where people climbed up and they were killed. And the bridge where Polansky was wounded is fully repaired. All this actually destroyed all the proofs which might be used for investigation. On the Institutska, the bricks of payment were intentionally removed. That general, SBU general, who was charged, he was released, keeping in mind his separatist views and separatist views of his legal advisors. We believe that he might evade from responsibility. I would like to tell you what's going on in Statutska. On September 2018 and in 19 the Kiev Court of Appeal had imposed an arrest, a seizure on Institutska Street, and any changes in the exterior of the street is prohibited. Institutska Street will not be changed, and since it is a proof used in the criminal investigation. I wanted to add about Institutska Street. I agree with Alexander that with Institutska Street we have a firm position. Why investigative experiments are needed while we have imposed a seizure on the street? The investigators' experiments were carried out in 2014, 2015, when the criminal materials are filed and are filed to court. Then the need sometimes appears to carry out additional investigative experiments. Besides that, we may expect to find new video recordings, new video proofs of what had happened. That is our position is that by the moment of final court decisions about February 18th, February 12th, no proofs from Institutska Street should be removed or damaged, because there are always a possibility that the need might appear to double-check the investigation experiments. That is, by the moment of final court decisions in those proceedings, in those cases, we should not release that street from seizure, so to say. That is, Ms. Tamara mentioned the facts which now do not happen. Sometimes there are facts when cars enter the museum, and now I requested that big cars or buses should not pass through the street. Even when we plan to impose temporary road signs, we request for special permit and do not allow to put them, because we want to prevent change of the street landscape. The general was released for his with his personal promise. So the documents that he provided, I think they are insufficient. Maybe the prosecutor's office may do something. Unfortunately, I do not hear what they discuss. Let us split the question into two parts. First part is how to change the detention measure. We do not see any reasons why he was released. He didn't. The court had no sufficient reasons to release him. On the other hand, when the court decision is in place, the prosecutor's office cannot do much to change the situation. We cannot, according to our legislation, we can do nothing actually. And we can only follow up whether the charged person or alleged perpetrator complies with the conditions of release, and here much will depend on whether they violated. He was released under false documents. Who has to be responsible? Let me clarify which document do you mean, and criminal investigator will decide what could be done. I have a question. I am Inna Plєханова, mother of Alexander Plєханов, who was killed during Maidan events. I believe my question is to Ms. Venediktova. You mentioned that there is no control on investigation and no pressure. When Ms. Venediktova is not on site, then who takes responsibility? Ms. Venediktova is in the office all the time. Ms. Venediktova is in the building, in another building. There is the criminal and procedural code who sets who is the leader of the criminal and procedural institution. And it clearly sets that director of the National Investigation Bureau, they are not leaders of the investigations team. They cannot make orders or to set tasks for the investigators. To whom the investigators are subjected, to whom they report, to the prosecutors. So this is about the split of responsibilities between NBI director and procedural He explains in detail responsibilities of all the officials. This is about Babikov. Frankly speaking, it's difficult to understand what she means. She makes some assumptions, or she has some understanding how the system works, how the criminal procedural code works, and he tries to explain to her how to explain to her to the situation. She makes assumptions about potential claims submitted by Yanukovych, etc. Would you please mention at least one person who was brought to responsibility in line with Maidan cases? All you have the weekly and with no results. Now let's start our Q&A session. Юрій Орловський, Ukraine TV channel. I have a question to Mr. Donskoy. How many charges were brought forward according to Maidan cases? And my question to investigators, what is your strategy as to investigation of February 18th and 12th investigation, and what you plan to do in future? Thank you for your question.
As of today, we recognize that there are not many verdicts, 19 verdicts. This is about statistics on the Special Bureau of investigation. Also, there is statistics and territorial bodies of prosecutor's office. Now I'm saying about department. 19 verdicts, 20 people were recognized as guilty, 26 indictments were also filed. This figure concerning the indictments, it is more fair than the number of verdicts, only because the side of prosecutors, in accordance with the criminal code, the side should observe the limits of pre-trial investigations, and the court is responsible in accordance with Article 28. And I repeatedly said that objectively the terms of court hearings, they cannot be different. I mentioned the example of the case of 20th of February. This is a difficult case, and the side of defense raises questions about each evidence, and the evidence should be checked in the course of the court hearings, and taking into, especially taking into account the number of defendants. And also attempted murders, about these cases there were less hearings, and the cases were heard in the longer terms, not because the court worked improperly, but because of objective reasons. This process cannot be faster if you want to have justice and to observe the rights of everyone for fair trial. For example, I cannot say that we can compare these cases. We may compare it according to the complexity and number of people. Marinchuk, gang about 30 murders, and in our case we have 48 people who were killed, and 55 in our case. So there were people who were close to the leadership of the gang, and they provided evidence. They provided evidence concerning crimes that were committed and informed about the circumstances and cooperated with investigation and the court. And if we are speaking about the case of 20th of February, no suspect cooperated with investigation. They didn't even provide their version. They didn't provide any evidence to the court. They didn't recognize anything, and they provide some information to the media, but in the courtroom they didn't provide any evidence. This is for comparison of cases. This case, considering the terms, this case is not unique. Why it is considered for so long? The cases where we have a lot of victims and the criminological characteristic is difficult. These cases are heard for a long time. At the same time, there are separate cases, and we always speak about it openly. There are elements of delay. Court hearings are appointed once per 2 or 3 months or half year. There are such cases. Even in cases where there is one episode and a person recognized that he is guilty, in the case of Christian. We may address with the complaint to the High Council of Justice. In case of delay, the reasons are different. Sometimes they are objective. Sometimes we cannot understand why they delay the case. But we believe, and we have requirements to the prosecutors, what actions that they should make during the process in order to move the cases faster. And now this work is ongoing, and we believe we ask prosecutors what they do in order to move these cases forward faster. I would like to add about pretrial investigation. Now, the continuity is provided, and the work between investigators and prosecutors is ongoing. And in the State Bureau investigations, there are some cases that are submitted from prosecutor's office, and there are more than 60 cases that are suspended, and the investigators took these cases, but half of these criminal proceedings they ended in order for detention to put these people into custody. Now the leadership of the department today they had a meeting and they identified the schedule for the next several weeks. Each investigator will deal with the proceedings and provide information to the heads of department, and also will consider the tactics and prospect episodes. Also, the public should understand that the investigation is ongoing from morning till evening, every day. In one proceeding, we verified the legality of actions of 166 investigators and 76 prosecutors, and 94 judges are checked. And each person should be checked and to have some proceedings. This is in one case, and we have more than 50 proceedings like this. And the killings in Maidan, this case consists of 4,500 volumes, even more, and only half materials are accepted, and the investigators of the Bureau of Investigation, they help to deal with these proceedings to conserve all the evidence, to preserve all the evidence, and we have operative meetings together with procedural heads to coordinate the continuation of pretrial investigation. So I saw your response on investigative the coordination with Mr. Buryak. This is the head of our investigative department. This is the only head of our department. Taskazliuk, Ukrainian Week. We would like to see Mr. Rybashapka here, but Alexei Ilyich will have to answer. Mr. Rybashapka, in his interview to Interfax, he was answering the question about Maidan, and he provided an unexpected opinion. He said that former Berkut officers that they were in the pretrial detention facility for 4 years without trial, and also he said that some evidence, some volumes of the cases went missing, and he didn't mention what went missing. Maybe you know. Also, we are interested. Rybashapka said that now the indicted charges were not provided against those who ordered this crime, and I know that the court hearings are ongoing against these people who ordered. Maybe you believe that other people ordered this crime. There are many questions, and I won't comment on the interview, but I would like to answer about those issues you've mentioned in your question. Often it happens so that the decision of the court, in accordance with the criminal procedural law, this is the verdict, and this there may be some, I do not know whether it was a video interview or they recorded it. Maybe in some stage there could be a mistake, and they cannot be without trial for 4 years, but the decisions about restrictive measure, it was taken each 60 days, so the court continued their detention based on the grounds of the charges and the evidence that were provided, and the court provided the decision on this. Maybe there is a mistaken interpretation that was not about decision but about the verdict. This is the first aspect. Second, about those who ordered in the middle level. In our criminal procedural code, it is stated what is bringing to criminal responsibility. And the start for the bringing to criminal responsibility is there should be charge against the person first. So all the mid-level and all top officials, they were provided with the charges and brought to criminal responsibility for 18th and 20th of February 2014. We know who provided these orders, who transmitted this order, who implemented these orders, and charges were made. And the court provided the permit. The court took decision to put them in custody. Some of these people were taken into custody, and the court, each time when it takes such a decision, they do not decide whether these people are guilty or not. They verify whether there are grounds to provide the charges, whether this person may be brought to criminal responsibility. This is a mechanism that shows that there was evidence that was provided for detention or to provide restrictive measure. These measures should be enough, and based on them, the court should provide the permit for detention. Going forward, I would like to say when we are speaking about top officials, the majority of those people in February 2014, they fled, and until now they are hiding from the prosecutors. And the procedures now in place to bring them to criminal responsibility, those procedures that can be carried out in absentia. Of course, we believe that if, for example, in the nearest future, changes will be made to the criminal code concerning trial in absentia, we have everything ready in order to legally, not only during press conferences, to provide answer to all these questions. So people will be brought to criminal responsibility. We hope that this decision on trial in absentia will be provided for, and we will send these cases for considering of the case in absentia, and everyone will be able to see the evidence we provide. And then the court will be able to take decision even if these people won't come to Ukraine. But this issue of trial and abstention should be unblocked. There are no verdicts against these people because these people went missing. They did everything possible to avoid punishment. They fled the country after these bloody events. So these people are brought to criminal responsibility. We are waiting for the opportunity. As I've said, even if they won't come to the country, we will be able to bring the case to the court. About lost missing evidence. Briefly, maybe you are speaking about those 2 volumes of criminal proceedings that happened to be in Partnov's possession. I didn't see what is there in these volumes. We saw only a cover. And in these are the materials as of 2014, and we cannot say what is in these volumes. And at the same time, when these volumes appeared in the media, inventory was carried out for the materials. Proceeding number 1455, and it was revealed, as I know, that evidence didn't disappear. What Mr. Portnov has shown, maybe there are copies of video footage that was made and it was handed over later on. I can only say one thing. There are no verdicts, no charges, and this case of these missing volumes, this case is investigated by other body, but the investigators, they believe they know what these materials are and how they were provided to Mr. Portnov. So they mentioned the allegations, and we believe that there will be proper assessment of how these materials appear in possession of Mr. Portnov. Елена Бережная, Director of the Institute of Legal Policy and Social Protection, named after Бережна. I have a question to investigators and representative of prosecutor's office about the case of 18th of February 2014 about Vladimir Konstantinovich Zakharov, programmer who was killed in Lipska Street, and Tatiana Chernovil had the crowd done, and who is not responsible for Igor Bachinsky. He died in the hospital. Baikov died from the stroke. Olga Burak died on the 10th because of contamination of blood, and many others. Did you send, as a procedural head or the investigators, did you send information to office of the president to deprive these people of the status, those people who do not relate to killings in Maidan? And do you investigate the crime concerning illegal seizure and state seizure in result of legal actions in Maidan? First, speaking briefly about this, about Zakharov. Maybe you know about the killing, and experts who carried out medical forensic examination, they have different opinion on this. The reason of the death is poisoning by gas, and there is no there are no wounds from bodily harm, and there are no signs of bodily harm on him, so we do not have grounds to say that he was killed. I believe that maybe Mr. Zakharov, he has relatives who may address the General Prosecutor's Office and may get information about closure of the case, and will take decision on this. I understand your question once again. Next. There was a question. I would like to mention that concerning those people you've mentioned, investigation was carried out about the circumstances of their death and the facts were studied. But prosecutors and investigators, they do not have responsibility to provide information about availability or absence of grounds to provide some awards or gaining status. So these are not our responsibilities. We should carry out investigation and establish whether there was a crime. And the assessment of these people, this assessment was provided, and any information, provision of information to presidential office or other institutions about the status, this is not the responsibility of prosecutors general office. And if a person addresses us about the results of investigation, we will provide this information in the volume that do not contradict to the secrecy of the case investigation. I would like to say in the Bureau of Special Investigations, and there is no criminal proceeding on the fact of the state coup. There is no such proceeding. They investigate the crimes starting November 2014 connected with the murder and attempted murder. If a person addresses about this fact and there was such an address, I know it from the media, maybe you should ask those bodies and the heads who deal with this proceeding, but we do not study this episode. Громадське радіо. What is your opinion? Can a second or a third person has access to the cases? Who do you mean? I mean not investigators and prosecutors. They other people, except investigators, they do not have access to these materials. And about the killings of law enforcement officers in Maidan. I do not know whether these proceedings were provided. I cannot comment about this proceeding. I do not know about it. But when the State Bureau will get it, the only prosecutor, investigator, and no one else will study it. Only if it is a lawyer of the defendant, but only with consent and permit from prosecutor or investigator. And we will study the risks, whether it will influence negatively on the case, and then we will decide. When I provided cases during pre-trial phase, I always mentioned that there is a criminal responsibility for disclosure of this information. And when we provide permits for search, for access to documents or other events that need sanction of the court, we ask judges to provide that other side is not allowed to be provided with data. For example, another side may ask, why did you sanction some search? And there is a practice that the court does not provide materials for to see to other people. And some materials concerning attacks and killings of law enforcement officers in Maidan, some materials are published by provided not by prosecutors and investigators. Can another side publish them, taking into account the leadership of the Bureau? These materials are provided from the prosecutors and who worked in Borisoglebsky Street 18. These materials are provided to the investigators in Borisoglebsky 18. And first cases, we took 2 or 3 cases, and they were provided to State Bureau Investigation, and other cases, they were handed over from prosecutor to investigator with proper letter or documents, and it is registered in the State Bureau Investigation, and the cases are in the same room. We have new safes, and no one, only investigators have access to these safes, and if information appears without sanction, so the investigator is responsible because only this person has the key to the safe, and only investigators have these keys. Also, I would like to add that about 3 proceedings these were stopped, and the court provided permit for detention in order to hold these people in custody. And the first 3 cases were provided to State Bureau Investigation, and all criminal proceedings that they are in the rooms of the investigators, and I get them, and no one take them away. We have new safes. They do not. They stay in one place, and also practically, Buryak Alexander Alexandrovich, he won't be able to read these materials, these proceedings. I have a question about Babikov. We had a precedent at the end of December when document was sent to court, and we see now the consequences of reshuffle, and maybe during pre-trial phase, maybe Mr. Rybashevka or Ms. Venediktova, Babika, maybe they will make some reorganization, and they will put people they need in some positions, and then you will be returned, but they will do they want to do. And a person lied publicly that he was not a lawyer of Yanukovych, and Venediktova said that he doesn't take into account the position of the relatives of the Heavenly 100 heroes. So, and why do we need this rifle that is hanging on the wall? And is there any risk that this story will repeat in some time? And what is the difference between the General Prosecutor Rybashevka from the head of the State Bureau of Investigation, Mr. Venediktov? General Prosecutor has procedural responsibilities. He appoints prosecutors and may replace them, and for this there are envisaged by law grounds. And he assesses the situation and takes procedural decisions. Ms. Venediktova does not appoint investigators for the case, and these investigators are not appointed by a pre-trial investigation. So the head of State Bureau Investigation cannot appoint these investigators. And you asked about the risks, and do we have facts? And we may speak about the risks. In Ukraine, they are in different areas, but are there facts? Because several weeks ago, Alexei was also concerned about it, and several weeks passed, and as I've seen today, that his concern disappeared because he thought that the investigators have efficiently work, and they move the cases forward, and the investigators, they get not only the proceedings, but also they get those proceedings from those investigators who didn't pass to State Bureau investigation, and they study these cases and they see what their predecessors didn't see, and they see that they may work on these cases more, they may make charges, and some cases were believed to be without good prospects, now they are considered as those that have such prospects. So if a person does not have any relation to me and to my proceeding or to my nomination or to my inclusion or non-inclusion to investigative group, I cannot tell about those risks. And about the family of Heavenly 100 Heroes, you should address this question to the head that has the responsibility to appoint people to positions. As a former investigator, and we may say that there were no interference. When the head was Sergei Viktorovich Gorbatyuk in the Bureau of Special Investigations, I may say that there was no pressure or influence on me to force me to take legal decisions, and during 4 years we didn't have this, and now we are working for more than a month, and during this month I may say that we do not have such a pressure. If there are facts, if you have them, or prosecutors have them, you may inform us on this. If we know about such facts, we will provide this information, but there are no such facts. If you have them, please publicly tell about it. I would like to add one aspect. Dear journalists, those questions that are raised concerning appointments at key positions, this is not question to us. Here we have colleagues from, they are former investigators of Special Investigation Bureau. They are working and they may say only about what happened. And as of today, I may confirm, and we have cooperation among us, and we will provide results in the nearest future. And those things that I expressed, I do not reject them. The matter is only that these aspects were not implemented, and I hope they, my concerns won't go into reality. And if need be, I will inform you on the situation. But as of today, you may not ask us about appointments. This is not what you may ask us. And about the change of the group, I stated my position clearly in December. As of today, once again, I'm included in the group on the 20th of February, and I believe that the responsibility for the result is that and this is a positive thing, that this case was returned to us. And about guarantees, the guarantees should be provided and envisaged by the legislation, and no one should take decisions if they are not envisaged in the criminal code. There are no guarantees. I believe that those decisions that were taken about the old composition, I consider this positive. Simskov, Simonov, my colleagues, they bear full responsibility for the case they dealt before, and the society may ask results from these people. And taking this into account, this is a positive thing, in connection with which I do not want to go to the situation that happened in December, and I provided my comment today on this case. Олександр Чорноблавський, Нескорений Майдан, 1802 Union, and we represent interests of those who suffered on the 18th of February. 5 cases we deal with. We deal with 5 cases. And you say that you have good communication, but there are many complaints because of the response of the prosecutors who support the verdicts in courts, and there are cases against ex-commanders of Berkut. I attended 300 court hearings. 100 of them didn't happen, were cancelled. I have a full archive of data on this, and 80 they used the provisions of the criminal code that allowed them to break court hearings, and the devil is in the details, as they say. Yesterday and the day before yesterday, the lawyer of defendants, when the judge is trying to continue the consideration of the case that is ongoing for 5 years, and 25 to 40 were provided evidence. And when will this case end? Because there are too many people who provide evidence, and the judge is trying to create a schedule, but there are 40 days, and during 21 days out of these 40 days, she cannot be present. I mean, this lawyer. So what can be done with such a situation? Because the situation is ongoing for 5 years. So these laws demand requalification. And during for example, she may say, I attend the court on economy court on other case, and for us it is laughable. They do not confirm that they, for example, fell ill, or for example, there was a traffic accident, a dog was hit, and people come from all over Ukraine, and they say that they didn't attend court hearing, for example, because there was a traffic accident. And we have a lawyer here who may confirm this. Олег Король.
This could be called the abuse of procedural law, because prosecutors take a passive position. And we encourage you to check that medical certificates or other documents which are issued in order to hamper the proceedings. Quite often we hear that the courts and lawyers, they are overloaded, and we suggest to introduce temporary changes to the criminal procedural court code, and allow judges and release judges from other cases, but in order to allow them to proceed with the cases which are already authorized on them. Sometimes the criminal procedural code sets only only 1 hour. The flood of uncontrolled speech, unfortunately, this is impossible to translate. What is the issue actually? When a lawyer explains that he is unable to participate in the hearings, suggests that this lawyer is unable to continue with this court case. It's not clear what they've been discussing. They're discussing potential amendments to legislation to prevent abuses and etc. When we try to bring legal advisors and lawyers, trying to bring them to responsibility, they never were punished. That is, the bars associations and bar discipline associations, they actually do not bring lawyers to responsibility. So here we are in the vicious circle, and we cannot do this. We do not hear what he is shouting because he does not speak to the mic, and it is obvious that they are simply quarreling with each other and blaming each other in something. Our prosecutors keep thinking on this issue, what we can do if lawyers are unable to carry out their functions of defenders in a court proceeding. Then perhaps he could not be a lawyer. We will try to bring this our stance to court, and we will see what decision will be made by court. Then about your claim that these are very long court hearings. Of course, we should resolve this position somehow. But the previous experience of all our suggestions to improve legislation, it just demonstrates that it never was supported. Again, this is the list of complaints, what is not heard. Dear friends, our time slot is exhausted. Thank you for your attention.
Піаритесь на родинах Небесної Сотні. Не робіть цього. Ми всі ходимо по українській